Welcome to Bankruptcy Bytes, a video series presented to you by the United States Bankruptcy Court for the Eastern District of Missouri. I'm Matt Rodman, attorney advisor to the Clerk of Court, and today's video is titled Anatomy of a Chapter 7 Case, where we'll go through some of the ins and outs of what you can expect in your Chapter 7 case. Before we get started, it's important to understand that the clerk's office and its staff is strictly forbidden from providing legal advice, as we have a statutory obligation to always remain neutral. Everyone's situation is different, and for the best individual assistance, the court strongly urges all debtors and prospective debtors to speak with an attorney to get expert advice on the right path for them. There are multiple types or chapters of bankruptcy case, each laid out in Title 11 of the United States Code. We call this the Bankruptcy Code. Each chapter applies to a debtor based on their unique circumstances. Considerations like whether the debtor is an individual or a business, or the amount of debts and liabilities that debtor has, are among a couple of the many considerations that help determine the best chapter for that debtor to file under. In this video, we will focus on what to expect in a Chapter 7 case filed by an individual debtor, sometimes referred to as a consumer Chapter 7 case. Before we get started, there are a few things you need to know about the bankruptcy process. A Chapter 7 case starts with the debtor filing a bankruptcy petition. The debtor will need to file other documents either along with their petition or within 14 days after they file their petition, but we'll discuss that more later on. The goal of a Chapter 7 bankruptcy case is a fresh start or a clean slate for the debtor, and this is achieved through the discharge of most debts at the conclusion of the case. Some debts will not be discharged for public policy reasons. For example, child support obligations or domestic support obligations will not be discharged. The Bankruptcy Code lays out which debts will not be discharged. With few exceptions, all debt collection efforts against the debtor are halted when a debtor files their bankruptcy petition. This is called the automatic stay, and it is provided for in Section 362 of the Bankruptcy Code. Lastly, all of the property and assets that the debtor possesses at the time they file their bankruptcy petition forms what is called the bankruptcy estate. The bankruptcy estate is administered and cared for by the trustee assigned to the case. The trustee will liquidate the bankruptcy estate and use it to pay back creditors to the fullest extent possible. Now that we know some key concepts, let's dig into filing requirements and the timeline you can expect in a Chapter 7 case. The length of a Chapter 7 case generally spans about 4 to 6 months, but the length of the case is going to vary based on the unique circumstances presented by each case. It is possible that they take longer. However, the debtor's work begins well before they ever file their petition to start their case. Before filing their petition to start their case, the debtor must complete a credit counseling course. This course must be completed within 180 days before filing the petition. For example, if I wanted to file my bankruptcy petition on Christmas Day 2023, I must have completed the credit counseling course between June 29, 2023 and before I file my petition on December 25th, 2023. If you have not completed credit counseling before you file your petition and you do not meet the requirements for an extension to complete the credit counseling after filing, your case will be dismissed and you will not receive a discharge of your debts. Credit counseling courses typically last 60 to 90 minutes, and they may be completed in person, online, or over the phone, but they must be taken with an approved credit counseling agency. Linked in the description of this video is a list of approved credit counseling agencies. Once you complete your course, you will receive a certificate of completion for your credit counseling course. This certificate will be submitted to the court as proof that you have met this requirement. Okay, so you've completed your credit counseling course and you're ready to file your Chapter 7 bankruptcy case. Now what? On day 1, you must file a bankruptcy petition, a creditor matrix, a verification of creditor matrix, and submit your filing fee of $338. Please note, this filing fee of $338 is subject to adjustment in the future. Instead of submitting the filing fee, the debtor may file an application to pay the filing fee in installments or an application for a waiver of the filing fee. Information on both can be found in the video description below. Please note, the court cannot guarantee that either application will be granted. While the bankruptcy petition, creditor matrix, verification of creditor matrix, and filing fee are all that's needed to open the case, the court suggests all other documents be filed on day 1. At the very least, we suggest that you file official form B-121 on day 1. Official form B-121 is used to tell the court about any Social Security or federal individual taxpayer identification numbers you have used. Once form B-121 is filed, the bankruptcy court can set a date for the Section 341 meeting of creditors and mail a notice to you and any creditors listed on your creditor matrix entitled Notice of Chapter 7 Bankruptcy Case Meeting of Creditors Deadlines. This notice serves to notify your creditors of your bankruptcy case and provide information about court deadlines and the Section 341 meeting of creditors to take place. The longer it takes for you to file your Form B-121, the longer it takes to set your Section 341 meeting of creditors. Note, the Form B-121, if not filed on day 1 of your case, must be filed within 14 days after the petition date, which is the date you filed your case. Failure to do so could be grounds for the dismissal of your case. You can bring your filing fee, bankruptcy petition, creditor matrix, verification of creditor matrix, and all schedules and statements to the public service counter of the bankruptcy court clerk's office for filing. The filing fee must be paid via cash, cashier's check, or money order in the exact amount due. The clerk's office does not give change, and debit and credit cards are not accepted. If the debtor files only their petition, creditor matrix, and verification of creditor matrix, and submits the filing fee on day 1 of their case, the work isn't over. There are a few documents that still must be filed before day 14 of their case. First, you must file the certificate of credit counseling that you received upon completing your credit counseling course. Next, you must file the rest of the documents that comprise what's called the bankruptcy petition package. This includes your schedules of assets and liabilities, your schedule of income and expenditures, and the statement of financial affairs. You can file these at the public service counter in the bankruptcy court clerk's office in the same manner you would have filed your petition, creditor matrix, and verification of creditor matrix. A full list of the required documents can be found linked in the video description below, and all forms can be accessed on the U.S. Court's website at www.uscourts.gov. After you have filed all the required documents, schedules, and statements, the next step is to provide your trustee with a copy of your most recent federal tax return at least 7 days before the date first set for your Section 341 meeting of creditors. The contact information, including address, for your trustee will be listed in a notice you receive entitled Notice of Chapter 7 Bankruptcy Case Meeting of Creditors Deadlines. You receive this notice from the court after filing your bankruptcy petition. This is the same notice that your creditors receive, informing them when the Section 341 meeting of creditors will take place. This step of providing your most recent federal tax return generally takes place between day 13 and day 33 of your case. Continuing on, you'll need to file a statement of intention. The statement of intention may be filed with your bankruptcy petition package on day 1, but it must be filed within 30 days after the filing of your petition or on or before the date first set for your Section 341 meeting of creditors, whichever comes first. The statement of intention is a document that addresses your secured debts, which are debts in which there is collateral or property promised to your creditors in case you fail to pay them back. Examples of secured debts include car loans and mortgages. The statement of intention describes your plan to either surrender or keep any property securing your debts. The statement of intention is often filed between day 20 and day 30 of your case. So, what is this Section 341 meeting of creditors we keep talking about? The Section 341 meeting of creditors is a chance for the trustee assigned to your bankruptcy case, as well as any creditors wishing to attend, to ask you questions regarding your financial affairs and property. This is not a bankruptcy court hearing. There will be no judge present during this meeting. However, you will be placed under oath as you answer questions regarding your financial situation. How do you get notice of this meeting? Well, we've mentioned it a couple times, but after filing all the necessary documents to open your bankruptcy case, including Official Form B-121, the bankruptcy court is going to mail you and any creditors listed on your creditor matrix a notice entitled Notice of Chapter 7 Bankruptcy Case, Meeting of Creditors, Deadlines. This notice will inform your creditors and you when your Section 341 meeting will occur. This meeting generally takes place day 20 to day 40 of your case. You must attend this meeting. Currently, the United States Trustee Program is holding Section 341 meetings of creditors telephonically. Call-in information for your meeting will be listed on the notice that you receive. Next, within 30 days after the date first set for your Section 341 meeting of creditors, you must perform what is outlined in the statement of intention that you filed. This step will generally be completed between day 50 and day 70 of your case. Now it's time to take another class. In addition to the requirement that you take a credit counseling course before filing your case, you must also take a financial management course from an approved agency before your case can proceed to a discharge and be closed. A list of approved agencies will be linked in the video description below. Some approved agencies will notify the bankruptcy court when you complete this course, but it is your responsibility to make sure that the bankruptcy court has notice of your completion. This can be done either by filing a certificate of completion or filing Official Form B-423. Failure to complete this course and notify the court of your completion through the proper channels could delay your discharge or even result in your case being closed without a discharge. A debtor can expect to complete the required financial management course between day 80 and day 100 of their case. Again, Failure to complete this course and notify the court of its completion could delay your discharge or even result in your case being closed without any discharge granted. Also, between day 80 and day 100, you will need to determine if any reaffirmation agreements need to be filed. If you wish to keep certain personal property after filing for bankruptcy, you may enter into a reaffirmation agreement with your creditor. This must be done within 60 days after the first date set for your Section 341 meeting of creditors. In a reaffirmation agreement, you agree to continue making payments on a particular debt, such as a car loan, in order to keep that property, in this case, the car. If you are represented by an attorney during the negotiation of a reaffirmation agreement, and your attorney signs all the appropriate sections of the agreement, it is not necessary for a judge to approve the agreement. Depending on the circumstances of your reaffirmation agreement, the court might set your reaffirmation agreement for hearing. Particularly, if you are not represented by an attorney during the negotiation of your reaffirmation agreement, the court will set that agreement for hearing. The debtor must attend this hearing. At this hearing, the judge will review the reaffirmation agreement to determine whether it's in the debtor's best interest to approve this agreement. If approved, the debtor will continue to make payments on that debt and retain the property. If you've stuck around this long, congratulations, your Chapter 7 case is almost complete. At this point, you will be eligible for the court to grant you a discharge. A discharge is an order forgiving you from most debts. Once your discharge is granted, your creditors can no longer attempt to collect from you for the debts that were discharged. Please note, not all debts are dischargeable in bankruptcy. The timing of a discharge varies from case to case, but a discharge may be granted as early as 60 days after the date first set for your Section 341 meeting of creditors. After a discharge is granted, the bankruptcy court will wait to close your case a minimum of 14 days after the last order in the case is entered. The discharge order is commonly the last order to be entered prior to a case being closed. This 14-day delay allows any appeal-related deadlines to pass and is mandated by the Federal Rules of Bankruptcy Procedure. The decision whether to file a Chapter 7 bankruptcy case is a difficult one and should not be made lightly. The court strongly urges all debtors and prospective debtors to speak with a bankruptcy attorney. A bankruptcy attorney will be well versed in the Bankruptcy Code, the Federal Rules of Bankruptcy Procedure, and the local rules of bankruptcy procedure. These three sources combine to form the roadmap for a successful bankruptcy case. If you would like to speak with an attorney regarding your recent or upcoming bankruptcy filing, the Bar Association of Metropolitan St. Louis hosts the St. Louis Bankruptcy Pro Se Assistance Program. This program offers cost-free 30-minute sessions with an attorney where the prospective or current debtor can get the answers to some of their questions. To schedule an appointment, you may call 1-844-758-4059 or schedule online at www.bamsl.org/bankruptcy. Thanks for tuning in to Bankruptcy Bytes and learning a little bit about the ins and outs of a Chapter 7 bankruptcy case. I'm Matt Rodman, attorney advisor to the Clerk of Court. On behalf of the clerk and the entire clerk's office staff, we hope you find this information helpful and we wish you all the best moving forward.